And being probably one that suffers from a similar thing in that we're trying to make sure it's tight before we send that. I appreciate that. I just think as we talk about culture shift and making sure you're building positive, healthy relationships with the legislatures, because you know we get prickly.
This one I know about it, and I'm being slow.
Just try to let you know we get prickly. Yeah.
Senator Fuller, I'm still having nightmares about it because I just totally dropped the ball. I'm just so sorry about it.
So from me to you, heads up.
Yeah.
The legislature can get prickly if our letters aren't responded to. And that's all for me. Thank you very much.
Thank you much.
Appreciate you.
Thank you very much, Ms. Mitchell. I just want to check in with Ina, see how you're doing. You'll take a break? Okay, when we take a break, we'll take a break. Okay, we'll take a break for about 7 minutes, and then we'll reconvene, and then we'll finish this out. Okay.
Thank you.
Thank you.
If there are any folks who are going to re-enter the hearing, if you can just give them a heads up to keep their conversations low outside. And we're going to reconvene the appointments of Mr. Picker and Ms. Randolph for the PUC. Why don't we go to the issue of your priorities with regards to amending the ex parte PUC communications. Give me your thoughts, your concerns on transparency and accountability as it relates to the PUC. And I think, is this your subject matter from your subcommittee?
Yes,
Okay.
that Policy and Governance
All right.
Committee. Well, there's sort of two layers. You know, a lot of the ex parte rules are set forth in statute. So, you know, part of the question is what statutory changes, if any, are necessary. But the other piece of it is really the aspects of the rules that are within our control and that are either definitions or interpretations that the Commission itself has taken. And so a couple of the priorities that I see are having a better definition of what procedural communications are. Those are, by statute, not considered ex parte communications. And so one of the steps we need to take is to better define that and make sure that the definition doesn't get too broadened in practice and is more clear. One of the big policy questions, I think, both legislatively and internally are what are the commissioner's responsibilities for reporting? Currently, the scheme is set up so that interested parties have the responsibility to report in the same manner that the state Water Resources Control Board has the interested parties reporting, as opposed to the model of having the commissioners reporting, which is what the Coastal Commission does. So one of the internal steps we have taken is having some informal voluntary commissioner reporting. You know, we have a policy that we have, if an interested party meets with advisors, we go ahead and have the advisors report that and the commissioners report that and the substance of that communication. And that's something that we have done of our own volition and as a way to just bring a little more transparency to the decision-making process. Another issue the Policy and Governance Committee has talked about is should we have a pilot program where, you know, we don't have the statutory authority to prohibit ex parte contacts, but should we look at internally whether or not we need to be thinking about, are there proceedings where there should be more restrictions on ex parte contacts? And so our consultants have proposed, should we look at a pilot program to look and see how that process might work in individual proceedings, and have the opportunity to go through some full proceedings, look back, and analyze whether or not that had an effect on the proceeding and what that effect was. So we're looking at a lot of different internal options like that, and our next step is to meet at our August 26th committee meeting and talk in more detail about those and set out a plan where we can look at those issues step by step, because they each, have their policy pros and cons.
I would say the consultant committee recommendations with regards to the pilot program, as I think are not viewed favorably by certain members of the legislature. I think primarily Senator Mark Leno, chair of the Budget Committee of the Senate, who has a measure with regards to ex parte communications for the commissioners of the PUC. I would strongly suggest your engagement with Senator Mark Leno. He has a measure, and I think it's the clear desire of this committee, the Rules Committee, won't speak for everyone, to respect everyone's individual perspectives, that you work in a collaborative fashion with Mr. Leno. Mr. Picker, amending the ex parte policies of the PUC, what are your thoughts? What are your considerations? What are the proactive solutions, or it goes to the subcommittee and hence waiting for the recommendations subcommittee to the larger PUC commission?
This is a real challenging area of policy for me because I'm not a lawyer, and so this is a relatively new framework for decision making. I understand, however, what the underlying goals are. It's to make sure that commissioners make their decision based on the same record that everybody else can see, that there's actually a published record, that's what we use to make a decision. And if there are communications that take place outside of the process by which you set that record, so there are ex parte meetings, in some of our proceedings, you simply have to report that those meetings take place. That's a duty on the party. And the reason you do that is so that everybody else gets a fair shot to actually also speak to the commissioner. So that's fairness. And I actually understand that. Having that transparency and that fairness seems like a good thing. Other proceedings, we don't have any contact at all. Those are adjudicatory and enforcement type proceedings, and I can also understand that. There are a bunch of other kinds of decisions we make that we call quasi-legislative, because they're somewhat similar to what it is that you do. We're not talking about a specific company. We're not talking about a specific interested individual or individual group or individual company that's going to benefit. We're setting pretty broad policy. So we had 3 different reports. One actually was from Professor Asimov at Stanford. He said that you should leave the system exactly as it is, but you should observe it. You should make sure that you observe it. The second was from Ed O'Neill, who the governor appointed to look at modernizing. He said that probably the best thing to do is to get rid of the middle category, so it's either forbidden or it's allowed for you to talk to parties. And then the third one was no conversations with parties at all outside of the process by which you establish the record. So far, I got to say that the last one, where nobody talks to us, actually works the best for me, because then I have fewer meetings with people. But I also feel that I'll be more ignorant as a commissioner. And so I'm struggling with what the balance is here. I really am. And I'm listening to the comments we're getting from different parties.
Thank you very much. As you know, the ex parte communication issue with regards to the PUC rules is a serious issue, and obviously Senators Wayso, Chair of the Energy Committee, as well as Senator Mark Leno are following this Rules Committee hearing very closely. They're probably watching right now as we speak in real time. And they have policy measures on this issue. I think it would behoove both of you to engage with them sooner rather than later. We're going to table the ex parte situation. We're still going to switch it up a little bit, and let's talk about the potential regionalization of the grid itself with CalISO and potential governance restructuring, if you will, of other folks outside of California with PacifiCorp. What role do you envision the PUC to have with the potential merger of PacifiCorp to CalISO's grid?
I think we will have a very limited role in the actual merger into the grid, because most of what's new will actually be in other states. And what's really new is that the ISO will have a much larger role in terms of dispatching electricity to provide reliability across PacifiCorp's service area. The ISO, the California ISO, actually is already doing that on an informal basis with this short-term market they call the energy imbalance market. I don't know where we come up with these names, but what it means is that you sell 5-minute bits of renewable electricity across state lines. And that's good because we've actually been selling some of our electricity to other states. When we have excess renewables, rather than simply curtailing and losing that value, we're actually able to sell that to other states. Rather than having to build a whole new power plant just to meet that occasional need, we can buy a little bit from other states. And so far, on balance, California's been making money. Not much, about $10 million in the last quarter, but that's only the second quarter the market's been operating. If you add PacifiCorp to that, we stand to actually save more money and have a bigger potential landscape that we can sell into. So I think there are advantages. Our role will be to regulate PacifiCorp as a utility that operates in California. We already do that. That won't change. We will have rate setting. We'll make sure that they observe California environmental goals. We will continue to make sure that they operate safely. So that's our principal role. Now, if you go this formal route of actually allowing ISO to operate across many more states, I think that there are still many advantages to California. I think there are a couple of things that do happen. And so that I've been working with other Western commissioners. We're all trying to figure out what this means in terms of operations in the state, our local pricing for, say, transmission, and what it means in terms of the health of other utilities in our areas of responsibility. So one thing we've done as a body of Western commissioners is to look around to see what happens with other multi-state ISOs where you have single state regulatory agencies. And the most successful model is the Midwest Independent System Operator, the MISO. They actually have built into their governance structure an advisory body of state regulators who monitors markets to see whether there are violations of rules. And that, I think, is an important and valuable thing that we should start working toward here in California, is to form that kind of a multi-state market body. I'm not sure that FERC is quick enough to satisfy me. I'm not sure that they'll take action quickly enough on gaming and violations of our public's interest. So that's a snapshot.
Do you envision yourself having a role in the possible restructuring of a governance, new governance board, if this merger does come to fruition?
The way that the restructuring of the energy imbalance market took place is that the ISO assembled a fairly broad body of stakeholders, including state regulators. When they first started that, I wasn't on the PUC. Commissioner Florio represents the PUC on that body. And so it's fairly robust. And they actually produce reports have public meetings, their actions are noted in a lot of forums. What they did is, and they're still doing, is trying to figure out what is the governance body for this energy imbalance market that protects everybody's interest. So they haven't formalized their proposal. We're still all commenting on their straw proposal. Who gets to be a member? How you have fair representation from different states, because it's not going to be equal. The population, the amount of energy, the differences in interests just guarantee that it's going to be different. But the last I checked, you had states as diverse as Oregon and Washington all agreeing on the proposed structure that eventually will go to the ISO for the energy imbalance market. I envision there will be something like that. We will probably be represented, but right at this point, I think I'm waiting to see whether or not they actually get permission from the legislature to embark on that process, what kind of principles you give them, and then figure out how we best participate.
You stated a few moments ago, did you want to say something, Ms. Randolph? You stated a few moments ago that if a merger comes to fruition, that it is important to maintain California's clean energy climate policies. One of the concerns, obviously, it came up with Mr. Richard Maslin. I hope I am remembering the last name. Mullen, Mullen.
Dr. Mullen, Richard Mullen?
Yeah, Richard Mullen at CalISO was the potential exportation of thermal coal in the event that the merger happens. Obviously, the IOUs have extremely limited, coal exportation to California to generate electricity. We have some MOUs, obviously, Los Angeles, primarily LADWP. With that potential merger, do you see an inherent conflict with the potential thermal coal holdings and its exportation that would undermine our clean energy policies?
I'm not so worried in the case of PacifiCorp. Most of their coal resources are actually concentrated in a little area in the northern Rockies. And so it's sort of isolated from many of the other service areas, and it doesn't have a lot of transmission capacity to actually export large amounts of coal into the portions of their service area that would actually be effective in terms of trading with us. So I think there's a natural barrier there. I think that the maximum transfer capacity out of that Rocky Mountain service area is maybe 200 megawatts total. So I think that becomes easy because what we do is look at the SCADA data, or we ask CAISO to look at the SCADA data and make sure that we're not getting a lot of imports there that look like the energy profile of a coal plant. That's generally not too hard to do, but I think that we probably want to build that into the principles so that as we explore governance at that level, we would look at it from a market perspective if we can craft that multi-regulator, multi-state body.
Okay. Do you think, Mr. Picker, that it's a good use of ratepayer money to be utilized for criminal defense lawyers for the PUC?
I'm going to actually pass that to Commissioner Randolph because we've appointed a two-commissioner panel.
And you do have a former general counsel and former chair at PCC here, so.
And as a lawyer, I felt that it was better to turn it over. We do hear reports.
It's a good deflection too, Mr. Picker. You are diffusing power from,
Yeah, well, I mean, I will say, as you mentioned, I am a former general counsel of the Resources Agency, and I have certainly dealt with and managed outside legal contracts. It is not uncommon for a state agency to use outside counsel. In this particular situation, we had to use outside counsel because the AG's office declined to represent us because they were doing the investigation. So we start from the situation where we need outside counsel. So why does the state agency need outside counsel in this particular situation? We have the responsibility to cooperate fully with the investigation to provide the appropriate documents. We are required by Public Utilities Code 583 to ensure that we don't disclose confidential information that utilities have provided to us. So as a result, our document review process is more cumbersome and more extensive than a typical state agency because we have to make sure we're following those provisions and that we are also being responsive. And then we're doing the typical sifting for attorney-client, et cetera. Then our last responsibility is to ensure that when we have employees that are called as witnesses, not as targets, not as subjects, but as witnesses, they were, doing their job and they have been requested to provide information in these investigations. We want to make sure that they feel they understand the process. They have someone to explain the process to them. We don't have lawyers on staff who have that expertise, so we need to get that information from the outside. And those employees have a right to be able to speak confidentially to somebody who will explain the process to them, and so that they feel comfortable and that they are being frank and disclosing the appropriate information. And that law firm does not represent any subjects or targets of the investigation. They don't represent former commissioners of the commission.
So if someone becomes either a target or a subject, outside counsel that is paid by ratepayer dollars are not provided, but rather they themselves, either staff, commissioners, or former commissioners, would have to seek that outside counsel or counsel period on their own dime.
Correct.
Okay. Your answer, legally is a sound answer, which I understand, and I think you understand too that the perception for ratepayers throughout the state of California, what is sound legal? What is a sound legal answer with regards to anyone who's a witness as opposed to a subject or a target? They are employees of the state of California. It is a public commission. It is a public entity. For any actions or what they have made a witness, heard, what have you, et cetera, sound. For the ratepayers, not sound, obviously, and that's where lies the conundrum, because we live in this world that is a bubble for all to see, but it's not easily it's the word I want to use. It doesn't translate easily to working families, and I think you both know that. I would assume.
Thank
you, counsel.
I agree with you. It was a very painful decision, but I will go to your challenge that I need to be a leader. I saw my staff melting down. They had never had somebody come to the PUC and seize computers and boxes of files. They had never been challenged with a subpoena that was compelling them to come and testify before a grand jury. They didn't have lawyers who could explain what that meant and what they should do. They didn't have anything that they could hold on to. Because in the past, if anything had ever happened like this, we were assured that the Attorney General's office could represent us. So I don't want my staff to be afraid to do the right thing. I want them to know that we will give them the tools they need to be able to do the right thing. So as difficult as this is, for the reasons that you point out, as awkward as I feel about this, it puts me in a tough spot in my own head. I had to do it, and I will stand by it.
Okay.